Lordship.
Yes.
Lordship, I beg to mention item number 8 and 9, Lordship. 8 and 9, Lordship.
Huh?
Item number 8 and 9, Lordship.
Okay.
Lordship, the principal counsel, Mr. Luckham, is indisposed.
Who?
Mr. Luckham is undergoing treatment. He's out of station. So
8 and 9. Anyways, anybody wants to take an adjournment except the part of matters, take it. I have no problem with that. Ask it from him, they will give it to you. Whoever wants to do the matters apart from that can do it. Okay.
I am here 8 and 9.
Yes, Mr. Rahman, you were there?
Yes, I am ready.
On which item?
8 and 9.
Ah, yes. So they want an adjournment.
But Lordship,
You want to do it?
no, I want to do it, Lordship, because it's a long pending case. Washing up the proceedings.
That day I heard Mr. Luckham in this matter. On account of the counsel appearing on behalf of the petitioner.
he was not present, Lordship. He was not present, Lordship.
No, that whoever it was, somebody was present. This matter I fixed it today. Both these matters. I remember.
I was there.
Yeah.
I was praying on behalf of Sir Rahman. I was praying on
Yeah.
behalf of Sir Rahman,
So I adjourned the matter on that day.
Lordship.
Because
It was
of
on Tuesday, Lordship.
What was my opinion? Was it against you or in your favor?
In favor. Favor.
Huh?
I was favor on our favor.
Lordship, but my principal counsel is indisposed. He's undergoing medical treatment.
Okay, okay. Mr. Rahman can't help it.
No, Lordship, here.
Some other day.
Then,
You want some date fixed?
not that it, let it be after 20 July, because I am also undergoing treatment. I am from Delhi now, Lordship.
Okay, okay. We'll have it on after 20th of July.
After vacation, Lordship.
The courts are reopening
22nd.
on
22nd.
22nd. Can we have it on 22nd?
22nd,
Yes. At the request of the learned counsel appearing on behalf of
22nd of this month.
matter stands adjourned to be listed again on 22nd of July, 2024.
Right.
Term order passed earlier shall continue till then.
Lordship, I have similar prayer for item number 32. Lordship.
Can it be 22nd June, Lordship? Saturday.
This
June.
20 June.
22nd June is a Saturday, not
Then 24, 25.
24th of June. Okay.
24th of June.
Yes, any other matters?
Lordship, I have similar play for item number 32, Lordship.
Then you have already got one. How many? This is a pardon matter, not possible.
Lordship, the principal counsel is indisposed, Lordship.
Partner is can't help.
My lord, may
I've
I
already
mention item number 36, my lord?
Oh, nothing doing. On the last occasion, I gave you an adjournment, whoever was appearing on that date. And then no further adjournment. They just stay. I'm going to vacate the stay then. Nothing doing. Question does
Lordship,
not.
I'm not in,
It's a simple
Lordship,
matter. Can't help it.
The
man,
principal
Mr.
counsel is undergoing treatment, Lordship.
How can I help it? Okay.
And I'm
Why
not,
didn't you engage somebody else? I gave it on the last occasion time. That is why I adjourned the matter. Sorry.
Lordship, let it be after 1 week, he will be here.
Not possible. We have vacate the order. Then you may do well after 10 years. You have
Lord, that's-
2019,
that
Mr.
is some of the
Council,
one
you
which-
have, Mr. Council, from 2019, you have stayed the process of allotment.
Lordship, in between the COVID came,
So
so 2
what?
years was,
COVID or no COVID, how does it matter? After COVID is done after for last 3 years. Nothing doing. No
My lord.
adjournment on that.
My lord, may I mention item number 36, my lord? The leading counsel is from Delhi and then there's a prior engagement and the
Which one?
honorable. Item number 36, my lord.
20?
36, my lord. My lord, a date may be fixed.
36.
Yes, my lord.
When do you want it?
My lord, any day after 2 weeks, my lord. But my lord, a day may be fixed, my lord, on that.
Why? You can have it there. Okay. There's an interim order.
Yes, my lord. That's interim order.
Hello. We're doing it on 28th of June, 20. And interim order passed earlier shall continue till then.
Oblige me. Deep oblige.
Please, Your Lordship, I'd like to mention items 33 to 35, Your Lordship, on behalf of Livika.
Item?
Since she's indisposed, 33 to 35, Your Lordship. This matter may be listed after 2 weeks, Your Lordship, since
2
she's
weeks.
indisposed.
Okay,
And Your Lordship,
33 to 35.
May I please, Lordship, I beg to mention item number 41 on behalf of Sertaka Kichu. My senior is on
I
leave.
told you, all matters, if you don't want, don't do it, except partnered matters, where I'm not going to grant an adjournment. I'm only asking, if you are asking for 2 weeks, 3 weeks, then you get it from them, no problem with that. Okay? Let's take up. Yes, Mr. Advocate General, we see your presence here.
May I please, your Lordship? Your Lordship, my senior is in court one, on his selection court one, your Lordship. If the matter one who can be taken up after some time, your Lordship.
Because he's the Advocate General. We have to give a first hearing to him. Yeah, by the time I hear him, the senior will finish his matter.
Lordship.
Let me hear him first. Yes, what do you say, the Advocate General, on this thing?
I had the opportunity to look into this matter last night about all these papers. Though there are divergent views among the officers and the lawyers, I have come to some conclusion subject to final appreciation. The limited question here was whether the 2004 circular will continue to operate in the light of the 2015 notification. That is the limited question. And as far as the 2015 notification is concerned, that is one approved by the cabinet, approved by the commission, and it specifically mentions that it is in terms of the various high court judgments. So it is exhaustive. The difference between the two being the 2004 is restricted to one group, that is the work charge, while the other is for both work charge and casual. Of course, on the basis of scale of pay. In the 2015 notification, the special provision is once you have cleared 30 years, whatever be the reason, then you are entitled to be regular.
But you have to be scale of pay.
Right. That's blanket. That has been done so that keeping in tune with so many judgments which are coming now of the Supreme Court also. Even few days back, you may have seen that you just can't keep them like that. They are also entitled to certain rights, having put in diligently so many years of service. But at the same time, a portion of the 2004 circular is also in a way incorporated in the 2015 circular. It is incorporated to this extent that in the earlier circular of 2004, it was 50% by seniority, 50% direct. That has been modified in 2015 circular for a limited period of 5 years, wherein the seniority position has been slightly increased from 50 to 67.5% also, as mentioned in the circular.
Yeah.
So these are the broad portions in both these circulars. Prima facie, to me, it appears. This is not my final submission, just what I have seen. For me, I feel that in a way, the 2004 circular has been in a way incorporated in the 2015 circular itself. Because that provision of promotion and I'm sorry, of seniority and other portion of 50% reservation, that remains intact. Most of the other conditions that it should be verified, etc., I find substantially it is there in all these things. So I don't find, to my understanding, any serious discrepancy, though I don't have supporters in my line of thinking, but I feel that it has been in a way incorporated. Now, if we see the judgment of 2024, 2024 says that as far as this position is concerned, the 2004 circular is still in existence. It has to be respected.
You are referring to the coordinate bench.
Single judge.
Yeah.
That is incidentally of 2024. The division bench, Honorable Division Bench, doesn't seem to accept it. But towards the end, they say, anything which is not inconsistent with this 2015 position, which exists in 2004, that will continue. So these are the broad parameters of this. So if the 2004 in a way has been given credence even in the division bench order to this extent, and in any event, a single judge's order has to go in tune with the division bench's order. So I'm not getting into that conflict. Now, various views came out. In fact, we had a detailed meeting. I came little late in the night. Still, we had a discussion on this. So they say that 2004 will continue and 2015 will continue. So we have to understand in what context it will continue. Because 2004 is limited to work charge. It doesn't give any benefit to the other employees, casual employees also. So it is more restrictive, but it lays down the principle of direct and reservation
And the scale of,
by seniority.
and the scale of pay.
Yeah, scale of pay.
That is the major.
Main thing, scale of pay is there.
The 2015, you don't touch anything
30%, 30 years flat
and scale of pay.
scale of. But that portion of 2004 is in a way included in the 2015 because they say that the present scheme will continue, subject to this modification. So there is respect for both the schemes. And a natural corollary of it would be, if there is anything in the 2004 circular which conflicts with this, then the arrangement is that will not continue to that extent. This, in my humble submission, is this. So I don't see a conflict as such. It's more than, I still feel that whatever you had in 2004, in a way substantially is included in 2015. But the 2015 judgment also says, it refers to the earlier one. It does not say that is overruled or that is not in existence. More, I would say, harmonious existence. That is what ultimately it looks into as far as I'm concerned. Now, I've not gone into the facts of each case. The facts of each case are different. That's a separate issue altogether. So I feel, since this is a point of contest and I've reached a very close understanding of it, I think I may require one more sitting with them. One more sitting with the officers concerned.
Because what has happened is this,
Right,
2004 remains, I wouldn't say that.
Right.
And in view of the division bench order,
correct.
2004 remains till it is not inconsistent with the 2015.
Correct.
But if a person who is in scale of pay in 2000 scale of pay and is a work charge who comes within the ambit of 2015, otherwise if he completes 30 years, then if he does not complete 30 years out there, could he be then brought within the ambit of 2004? Because within that would be contrary to 2015, which the coordinate bench held, that he may not be entitled under 2015, but he's still entitled to 2000, even though he has a scale of pay.
Now, as far as 2004 is concerned, somebody may be nearing the eligibility for 2004 for several years. And the strength of the employees, I think it goes to more than 11,000 or so. It's not just, that is why the matter is little delicate. So it has very large ramifications. And I understand that the vacancies are not too much in that cadre. Whereas here you complete and you get. There is no limit. Subject, of course, to the condition you have to complete. And it's not that everyone would be fortunate to complete that because of our superannuation and so many other things, they join late, so they won't get that. Some of the few lucky ones will come in that, some may get here. So there is a dichotomy. Which I feel needs a little more introspection. I have understood it in its right perspective. If my lord would not mind, could your lordship repeat again the last portion which your lordship had just mentioned? I would like to apply my mind to it. Just now your lordship said that whether both can be applicable, kindly repeat that.
What has happened is this. Just for example, a person A has a scale of pay. In terms with scale of pay, if he has, in terms with 2015, he needs 30 years.
Correct.
If he has already completed 30 years as on 1/1/2015, then in that case, he is to be regularized.
Right.
After that, if he completes, after 1/1/2015, if he completes 30 years, then on 1st of July or 1st of
Right.
January the next year, he is to be considered. This is 2015.
Correct.
But if a person has a scale of pay, is a work charge and a casual employee out here, but does not complete 30 years, can you relegate him or give him the benefit under the 2004? Because if you give it there, then 2015 becomes useless, more particularly clause 1, Roman 2. Because then that condition of clause Roman 2 becomes useless. You can't, then everybody will go in 2004. I understand one thing, that in a 2004, there might be a question out there that these persons are for fixed pay. Taking into account the fixed pay, the government may think, yes, 2004, we are still continuing for the purpose that these people are fixed pay, they are not getting the scale of pay. So their enjoyment is less, for which we give a more accelerated benefit of regularization, because the other one has already got it. But again, there is a problem out here that a person who is in fixed pay, just for example, 10 years, 6, 8, 9 years you require, 9 years, he gets the benefit and he is being given this regularization. But a person who is having 29 years and retires, he getting a scale of pay, he would not be entitled to the pensionary benefits because he does not enter into the service of the state. So unless something is done, there is a lot of inequalities which is going to happen. So don't you think the government needs to come up with a more correct approach in respect to this? Because what is being submitted, that is why we requested you on the last occasion to come up with a solution, because there is varying submissions made by the state councils. It happened out here by the coordinate bench because of a submission being made. Yes, if he's not entitled to here, he will be entitled.
Supporting the 2004 circular.
That if he's not entitled, because if that is so, 1-2 becomes useless.
Otherwise, that order would not have been passed by Learned Single.
And this is what they are asking here. Now, if I pass this, 1-2 becomes useless. And one thing, whatever may be, the Uma Devi's judgment is one thing very clear, that the High Court does not have a power under 226 to direct regularization. The law is well settled. However, in the other judgment in 2017 by Justice Chandrasud, he opines out there to say that it is only the state who has the power to regularize. They may frame anything, because if there is any direction, it would be, or any other orders passed, it would have a consequences upon the state. After all, he is an employee of the state, or a court to direct regularization would be a case that you ask somebody to appoint, which power the court does not have. The court only has the power to ask if there is an unreasonableness, arbitrariness to consider. So he said that it is the state who does it. So if the state has to do it, the state has to come up with a more clearer scheme in that as to how to tackle this situation.
And even Umadevi judgment, though we speak a lot about it, I think it's more outdated today. In
But
the,
so 2017 also, it has been duly followed.
yes,
That stipulates this judgment. I
The-
just
in that
read the
judgment,
passage of this judgment of Justice Chandrasud in this case. It's a very beautiful judgment on that. Not getting it now. Internet is down. The very beautiful judgment, more particularly, it deals with what does, because issue arose after the judgment of Uma Devi. There were certain judgments passed by the Supreme Court even in the judgment of Rekha and all these things, whereby there was some diversion of the view from Uma Devi. So these were the three judges bench, and therefore they settled out that this law cannot be there because this will run contrary to Uma Devi. So this is how that. But day before yesterday, there was another judgment of, I think, Justice J.K. Maheshwari. It's a very recent judgment. Here is the case what had happened. The matter came up before these people were, the single judge directed regularization and granting certain benefits on the basis thereof. Matter came up before the division bench of the Allahabad High Court. Allahabad High Court said they're nothing doing. They cannot be regularized. The court cannot direct regularization, which is in terms with Umar. In the meantime, the appeal was filed. The Supreme Court stayed the thing in 2017. Now the matter was disposed of day before yesterday or 2 days back. It was stated out there that as they have been enjoying all this on the basis of the High Court's order, which runs absolutely contrary to Uma Devi, has been getting the benefit out there, then also, therefore, they should be granted all pensionary benefits.
I think Justice Vikram Nath.
Yes, yes.
I got that,
Yes, just
I
2,
got
3
it,
days
yes.
back.
just Vikram
Yeah,
Nath.
yeah, this judgment.
But the primary issue is in Uma Devi's case, they have specifically said, they have even mentioned about Supreme Court and even the other constitutional courts under 226, that they cannot give a direction like this. Very clear.
Very clear.
And that has to be followed. As far as though divergent views are coming from Supreme Court, sidelining in a way or giving their own interpretation. But that judgment is very, very clear.
And that is what,
Yeah.
after that, Rekha and all this came,
Yeah.
that is what, subsequently that judgment in the case of state of J&K versus District Bar Association, Bandipora. So there it's a 2017 judgment. There the Supreme Court said about this, it cannot happen out there. The justice, otherwise you are running counter to merely being there for a long time. Could not. In fact, in a very recent judgment of a constitution bench in the case of, it's reported in 2024, 3 SCC, page 799. There again, the court went into the question of legitimate expectation. It's a case on legitimate expectation. This matter pertaining to High Court of Kerala. You must be aware of that. It's a very recent. So there is some district as regards the district bar, appointment of district judge and all. The Supreme Court again refers to the constitution as regards Uma Devi and again reiterates that why there cannot be a legitimate expectation of a person, even a substantive or a procedural legitimate expectation is not there
You discuss.
because they don't have a right. The right is there, which even that the government is having doing somebody regularization also does not give them a legitimate expectation to be considered.
In fact, the word used, if I remember, is we will not treat it as a judicial precedent if our order is not followed.
Yes.
They're quite tough with the language also. And they are giving directions to every court,
Yes.
which means to the Supreme Court also. That is, you can't deviate unless a larger bench gives another judgment. Now, the difficulty which the courts are also facing today is people are languishing for 20 years, 25 years. It's actually a human right problem also. They also feel that they must also get their dues. So today there is a conflict between the law and the concept of justice. What they actually should be given. Now, until either a law is framed by the legislature or it is interpreted or laid down by the court, this confusion will continue. It is not that either of them are wrong. One is right and the other is correct. This is the dilemma in which we are today. So I feel that we are very close to the point, as I have understood it. But we had a very detailed discussion. I called everybody. first thing we did was that in the night. I think I require one more sitting. So
Mr.
that,
Advocate General, do you think that I should put this aspect, the query, which I am raising, in the order? So that it may help you out to
Please.
get a better, yeah.
yes. So that, so that they get the angle. So if we, if it's put there, so the thing becomes crystal clear. Then there is no diversion either way. And there will be absolute clarity. That will help us also to arrive at a.
You get a
suitable solution.
much clearer ear from them.
Yes, ma'am. That is, though it may not be a final, it is just
No,
a
that
type
is
of
the, and I'm,
giving the mind, it will actually assist us.
I'm putting it as a query.
Yes.
As regards how to do it.
That's it. I'm good.
Adjourn the back. Heard Mr. Mojami, the learned counsel appearing on behalf of the petitioner. I've also heard Mr. K.G. Balagopal,
KN, madam.
KN Balagopal, the learned edition Advocate General of the state of Nagaland, assisted by Ms. V. Sukre, the learned additional Advocate General. This court, by an order dated 6/6/2024, sought for certain queries, certain answers in view of the judgment passed by the coordinate bench on 27/5/2024 in WPC number 312/2021. First, today, this court had duly heard the learned Advocate General. Upon hearing, this court had put a specific query upon the state in view of certain prime facie in view of certain primary facie inconsistencies taken in the stand in WPC number 312/2021. The said inconsistency appears to be on the basis of a reading of the two office memorandums pertaining to regularization in the state of Nagaland. The first office memorandum is the office memorandum dated 22/9/2004, which specifically relates to work charge employees. In terms of the said office memorandum, there is no time period fixed when the state would take up the case for regularization. On the other hand, if this court peruses the office memorandum dated 17/3/2009 or 3, 17/9 or 3, 17/3/2015, it is seen that there are two preconditions for the purpose of being considered for regularization. First, the person, the employee has to be given a, have been, the employee had already been granted a scale of pay. The second is that he has to complete 30 years of service. In terms with clause 1 of the office memorandum dated 17/3/2015, if an employee who has already completed, he was in scale of pay, and have completed 30 years as on 1/1/2015, he would be considered for regularization. In terms with clause 1, Roman 2, if an employee, just madam, just when you put the employee, you put it work charge and casual, huh? Because otherwise contingency comes in. If an employee completes, who is in scale of pay, completes 30 years after 1/1/2015, the said employee would be considered for regularization in 2 batches, which would be in the period from 1st of July or 1st of January of the next year. First, under such circumstances, a question arises as to, no, first of, it is also seen from the judgment of the division bench of this court dated 17/2/2023 in writ appeal number 6/2022, wherein it was held that the office memorandum dated 22/9/2004 still continues to operate unless it is not inconsistent with the office memorandum dated 17/3/2015. First, a question therefore arises as to who would be entitled for the benefit of the question therefore arises as to what arises as to how the work charge employees, because in view of the fact that both the office memorandum dated 22/9/2004 and 17/3/2015 deals with work charge employees, would be treated. First, there has been from a perusal of both, from a conjoint reading of both the office memorandum, it transpired that there is a fundamental difference in both the in as much as those persons who are on fixed pay or have not been granted the scale of pay would be outside the scope of the office memorandum dated 17/3/2015. Under such circumstances, this court puts a specific query upon the learned Advocate General as to how the state respondents would be treating both the sets of work charge employees. Would it be a case of violation of Article 14 of the Constitution, taking into account that a work charge employee in a fixed pay would have an accelerated scope of regularization, whereas a work charge employee on a scale of pay would have to wait for 30 years. First, when do you want it? I think it has been formulated. When do you want it?
Whenever,
I can't trust when I am not there. In fact, I won't be here now. Let it come up after a year. I released from Parthat. I've never put it as Parthat, but anyways, they have put it as Parthat. When do you want it?
after a few weeks, I think this might maybe kept as at least part heard because
But that means I have to carry these files back home.
we will carry it.
Huh? Okay, we'll
Maybe
do one
kept
thing.
as part
Let,
heard.
let me fix it in the month of July.
Maybe.
Taking into account that the matter has been substantively heard. This court directs the registry to upload the to upload the not that this is already been to the same shall be the same has been kept as parted. Footstool. Taking into account that the matter has been substantively heard, this court keeps the instant matter as parted. Footstool. List the matter again on 23rd of July,
Maybe 25th or 26th in the last week.
25th of July.
Very-
25th
very
is
well.
not the last week, however. It's the 1 week before that, 25th
25th.
25th of July.
of late.
Population.
Well, I just want to mention there is one more matter which I have been asked to appear.
Yes, sir.
That is fixed at 2 o'clock.
Oh,
Yeah.
you see, Mr. Advocate General, I may have to adjourn that matter today. I'll have it tomorrow. Today I may
Very-
have
very-
to, sister, go with the Chief
Yeah.
Justice somewhere.
I'll appear tomorrow.
Tomorrow, let me fix those matters
Very-
tomorrow.
I'm of late.
List the matter. Inform me, where is Miss Jimomi? Z Jimomi. Where is it? No. Okay. You inform it, we take it tomorrow,
Tomorrow.
these items, which is there in the hearing. Huh? Yes, the last 10 matters. List the matter tomorrow, taking into account that the learned Advocate General, State of Nagaland, would be addressing, submitting his arguments.
Of late.
Yes, to be spoken to, there is item number 34. Who is there?
To be spoken to, item number 56.
Madam, I made the mistake on that day while dictating. What has happened? It is not a case of reversal. It was not a case of reversal, it was a case of affirmation. So if it is affirmation, it can be very well done without a de novo trial. So that day I was under the impression reading wrongly, means that customary court order, I couldn't understand the language properly. So there the problem happened otherwise. Yes. So now what is wrong? Why should this court interfere with that order? You see, the customary court has come up with a particular decision, saying clearly that, you see, all this while, whatever has happened, for last 14 years or 15 years, you have not agitated anything. One fine morning, how can you agitate about this dispute? And as such, the customary court say that nothing doing, he will be recognized to the effect. Now, the deputy commissioner does not go for a de novo. She finds on the basis of hearing that your petitioner number 3 have duly admitted that he did not know about the resolution. He sold the land to so and so. There was a demarcation being made properly by your brothers. Then why should the court, the district court interfere? Therefore, the district court affirmed the order or confirmed it as its own order. So against this, you have come before this court. What is wrong with that order? You are saying about the Village Council Act. There's some permission resolution here. But that resolution, the court, DC has duly taken note of it. And you can't say that, well, that was you passed in 1998. There's nothing out there. You don't have a case. I studied your file. I don't study because I thought that how is it possible it was not gelling the judgment was ready. It was not gelling. Then I sort of, oh, the problem arises because the DC was right. The DC did not go for a de novo because it affirmed it as its own organs. Don't help it. This court is not going to interfere on that. And the power which is doing exercise is 227. Why? There's nothing wrong with that. Can't help it. But one thing you tell me, what happened to your appeal to the deputy commissioner? You filed 2 appeals. What happened to the first appeal?
Worship, the first appeal was taken over by the Tobashi court. Worship. Appeal was filed against the order of the tribal council addressed to the deputy commissioner. And this was referred to the Tobashi court.
How can it be done?
Lordship, actually, this is not possible actually at the first place. Now, when a respondent aggrieved by the order of the Apex Tribal Council, so aggrieved by this order, the respondent village the
So against, but whatever may be, that tribal council's order is appealable to the DC or not?
yes, Lord.
You can't say no because you by yourself went there. So if it is appealable to the
Lordship,
DC,
against the tribal council order, it was the respondent village that went against, not us. The tribal council has directed to pay a payment of 25,000 each, 50,000 altogether. So we did accordingly. So aggrieved by this order, it is the respondent village that has gone on appeal, not us.
what happened to your appeal?
Your Honor, actually, the tribal council is, the rules for administration of justice does not speak of tribal council. It only speaks about customary court, the Bashi court. And accordingly, we file an appeal, we challenge this order before the DC. And the DC had given the direction that this matter has to be heard only in the court of the Bashi. Accordingly, the Bashi court gave the judgment in my favor, Your Honor.
So you mean to say that the tribal council would not come within the ambit of Rule 24? Rule 24? Would it come within the ambit of those? Rule 24? Any of these authorities? Because yesterday I got a very good enlightening of these rules by the senior counsel, Mr. Iral. Customer care court is not there. Because chapter 4A has not been brought in. Now the question is whether it will fall, the tribal council, the Tiki tribal council, would it fall within the ambit of those? Would it? Then in that case, his appeal which he has filed, was exercised in terms with 23A and referred to the Dobashi. And if it is referred to the Dobashi decided against that the appeal has been filed. What do you say? Tell me, if it falls under 24, I can help you or? Udit? Huh? Madam? Whether the Tiki Tribal Council will fall within the ambit of these authorities which have been mentioned in Rule 24.
No, your lordship, because Rule 24A says that they may not try suits in which a native of the plains or native of another village not resident in their jurisdiction is a party.
So it can't be.
They're two different villages.
Hey, give me the blue book. The blue rules of- So who will decide? If there is a problem between the two, it will be the village council. And if it is the village council to decide, would it not come under the Village Council Act? No, 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 no. The rules of 1937. Can the Dobashi court, in view of that, decide if it is a dispute between two villages? Can it?
Yes, lordship, if it is forwarded by the company, this.
No, no, that's blue book. Who is that? Yes, madam, kindly come to the mic.
Your lordship, Rule 23A says that the Bashis henceforth shall try and decide such civil cases only as may be referred to them by the deputy commissioner or the ATC.
Yes, very well. Done. But can the Dobashi court, because the power is again under 24. The power of the Dobashi court is under 24. Now, whether, because that is the power. And here 23A has been only brought in to show that others they can do. But the deputy commissioner, however, has the right to direct the Dobashi. The Dobashi otherwise can't do it unless the deputy commissioner directs. That is 23A. So under such circumstances, can a dispute between two villages be decided by the Dobashi court? Where is that blue book?
Lordship, this matter was heard in the Dobashi court only on the direction of the deputy commissioner. This is well mentioned in the order and judgment of the Dobashi court. Your Honor.
No, that I've seen. There's no quarrel with that. But can the deputy Dobashi court, in view of Rule 24, decide between two villages? That is the only question. Is it possible?
Your Honor, Section 23, Rule 23 has already imparted Dobashi.
Now, this is the decision is by the district head Dobashi court, Dobashi, Kifri. So does he have the jurisdiction?
Your Lordship, it says district customary law court Kifri.
Huh?
It says district customary law court Kifri, Your Honor. So
So
therefore,
it will call.
yes. So the Bashi Court has the power now.
Kini লেখা আছে দেই। Also seen that while the appeal was pending before the Deputy Commission, the district council had passed an order whereby a paragraph 4. Yes, your name?
Limadushi, Limadushi.
You give your name, huh? Then I will remove the name of the, earlier there was another person.
His Lordship.
Okay? First, taking into account, next, taking into account paragraph that the appeal, taking into account that the Tiki Village Council was not an authority within the, coming within the ambit of Rule 24 of the rules of 1937. The Deputy Commissioner, Kifri, endorsed the matter for decision in terms with Rule 23A to the District Customary Law Court Kifri for decision. The District Customary Law Court Kifri, by an order dated 30/10/2018, observe that the resolution so passed by the respondent number, by the petitioner number 1 village, petitioner number 1 hearing, being resolution number 5 of 1998, was not informed of dispatched any letter to neighboring villages nor published in the local media. It was further observed that the petitioner number 3 herein may not have been aware of the petitioner number 1's resolution. But after the purchase of the land by the respondent number 1 herein in the year 2000, Sri Tothong and Sri Tokim, bona fide citizens and residents of the petitioner number 1 herein and relative of the petitioner number 3, had verified the boundary demarcations with the respondent number 1 herein. It was further mentioned, observed, that the petitioner number 1 herein had not issued any notice to Sri Tonthong and Sri Tokim for violation of the resolution bearing serial number 5/1998. The District Customary Law Court further observed that the petitioner number 1 village had adopted a resolution being at serial number 5 in 1998, banning the sale of land using their jurisdiction. And if any violates, the land will be given by the citizens' union. But raising the issue after a lapse of 14 years was considered by the District Customary Law Court Kifri was as invalid. It was therefore opined that the respondent number 1 herein opined that the petitioner number 1 and the petitioner number 3 herein had therefore cannot therefore claim ownership of the land in question. Next. Being aggrieved, an appeal was preferred, being aggrieved, the petition, it is also seen that pursuant to that the district customary law court had also directed that in the circumstance anybody raises any dispute, the defaulter would be penalized with rupees 25,000. Full stop. Thereupon, the record further reveals that thereupon the president as well as the executive chairman of the petitioner number 1 village sought for a few days for consideration. Full stop. By an order dated 8th of November 2018, the district customary court, Kifri, observed that any individual and the party would be at liberty to prefer an appeal before any higher court. Full stop. It is also seen that thereupon the petitioners herein preferred an appeal before the learned deputy commissioner, Kifri, Nagaland. And in that regard, a receipt number 994 was issued. Taking into account that the said appeal was not taken up for disposal, a revision application was filed before this court by the petitioners, which was registered as CREV, Civil Revision, number 6/2019. This court, by an order dated 2/12/2019, directed the Deputy Commissioner, Kifri, to take a decision on the appeal so filed by the petitioners herein within 15 days from the date of the said order, and thereupon the decision be conveyed to all concerned parties. It is subsequent thereto, this Deputy Commissioner Kifri, by an order dated 14/11/2019. This was subsequent thereto, the Deputy Commissioner Kifri passed the order dated 18/12/2019, which have been impugned in the instant proceedings. Next. I've heard the learned counsel appearing on behalf of the petitioner. Full stop. This court have duly taken note of the submissions so made by the learned counsel appearing on behalf of the petitioner, comma, the respondent numbers 1 and 2, as well as the learned government advocate appearing on behalf of the respondent number 3. She submits, the learned government advocate at the outset submitted that this being a decision, that the petitioners ought not to have implemented the respondent number 3 to the instant proceedings on the ground that the order so passed was a judicial order, and against the judicial order, the judicial officer could not have been made a party. Full stop. In that regard, she referred to the judgment of the Supreme Court in the case of Savitri Devi versus District Judge Gorakhpur. Reported in 1999 2 SCC 577. Full stop. This court, full stop, before dealing the matter on merits, this court would like to deal with the submission so made by Ms. A. so and so, appearing on behalf of the respondent number 3. A perusal of the impugned order reveals that the respondent number 3 passed the said order in the capacity of a judicial officer. Under such circumstances, this court is of the opinion that the respondent number 3 ought not to have been made a party. In that regard, this court finds it relevant to quote paragraph number 14 of the judgment referred to by the learned counsel appearing on behalf of the respondent number 3. Which is reproduced here in below. It would next. It would be seen that the learned that the Supreme Court had in the above quoted paragraph deprecated the practice of impleading judicial officers who pass orders. Under such circumstances, taking into account that the instant matter has been finally disposed of, no useful purpose would be served at this stage for striking out the name of the respondent number 3. However, this court, taking into account the said judgment passed by the Supreme Court in the case of Savitri Devi Supra and the paragraph quoted herein above, directs the registry in future to make necessary inquiries to take note of the observations made by the Supreme Court in the above quoted paragraph. Next. In the backdrop of the above, let this court now consider the question of as to whether the judgment of the learned, whether the instant application under Article 2 to 7 of the Constitution merits any consideration against in respect to the order dated impugned order dated 18/12/2019. Next. In the foregoing paragraphs of the instant judgment, this court have duly noted the dispute so involved. This court had also taken due note of the order which was passed by the District Customary Court, Khifri, as well as the order which was passed by the learned Deputy Commissioner in the appeal filed there against. This court further takes note of Rule 31 of the Rules of Administrative Justice, of the Rules of 1937, wherein the relevant, for a proper understanding of the said rule, this court quotes the said, reproduces the said Rule 31. Next. From a perusal of Rule 31, it would be seen that the Deputy Commissioner or his assistant shall examine has the power while deciding an appeal to examine the parties, and if the decision appears to be just, shall affirm and enforce it as its own. It is only in the circumstance where the court sees reason to doubt the decision, doubt the justice of the decision, it would try the case de novo or refer it to a panchayat as above. In the instant case, a perusal of the impugned order dated 18/12/2019 would show that the learned Deputy Commissioner had duly also examined the parties, which aspect of the matter would be clearly seen from paragraph number 7. And thereupon had come to a decision that the judgment, that the orders so passed by the District Customary Court, Khifri, were just, and accordingly informed it as its own. Paragraph 7 of the order, impugned order dated 18/12/2019, would clearly show the said aspect of the matter which is reproduced herein under. Under such, this court is of the opinion that there is no jurisdictional error involved in the order being passed by the learned Deputy Commissioner dated 18/12/2019, inasmuch as the same is in consonance with Rule 31 of the Rules of 1937. Under such circumstances, this court finds no reason to interfere with the order dated 18/12/2019, for which the instant petition stands dismissed. You want cost? Stands dismissed. The is the order, Agor Kinias. Paragraph 4 of the coming in 5 minutes.
For admission, item number 6. May it please, Lordship. Lordship, on behalf of Takakichu, correspondent number 4. Lordship, the affidavit is ready. However, he is here to obtain the signature of the deponent. So kindly, this is a matter after 2 weeks, Lordship.
Mr. Counsel, I've told him in the morning, anybody who wants an adjournment, very well take it, except parted matters.
Lordship, actually, there is an interim, Lordship.
Hmm?
Interim, there's an interim.
You are paying for respondent number 4.
Lordship.
What
on
is
behalf
your
of
prayer?
Takakichu.
You want to file your affidavit in opposition.
Lordship.
You have not filed.
Yes, Lordship.
How, why
On
you have
behalf
not
of
filed?
Takakichu, Lordship.
Hmm?
The affidavit is ready, however, he is yet to obtain the signature of the deponent. Lordship.
But earlier you have taken many time.
Lordship, I'm mentioned on behalf of Takakichu, Lordship. I'm not in the case, Lordship.
The counsel appearing for the respondent number 4, further seeks for 2 weeks time
Lordship.
for filing the affidavit in opposition. First up, it is seen that on earlier occasions also, the counsel for the respondent number 4 had taken time. So considering the above, for the interest of justice, this court grants one further opportunity. First up, the affidavit. This is the matter again on, just put this, yes. Again on 4th of July 2024. First up, the affidavit in opposition be filed without fail by 2nd of July 2024.
Interim.
Interim order passed earlier shall continue till the next date.
Much obliged.
For admission, item number 7.
May it please lordship.
Hmm.
My lord, in this criminal appeal, I'm appearing as amicus curiae.
Hmm.
My lord, today is to only for IA, delay, condition of delay.
How much?
My lord, 1,455 days. I have explained, my lord, in my IA.
Criminal appeal for what?
Challenging the conviction order.
You are still inside.
Thank you very much.
Conviction of how
Yes.
many years?
10 years. And convicted in 2018. I was, legal service authority had requested me to appear as an amicus curiae.
You are appearing for whom?
State.
For the state.
I'm appearing for the respondent number 2.
Hmm.
Uh,
This is a matter, POSCO?
Lordship,
What matter is this?
Lordship.
POSCO,
POXO as well as RAP
POSCO.
allegations of.
POSCO.
and I've been appointed as amicus curiae for respondent number 2. Because in spite of the notice, no one has appeared for the respondent number 2. He's the informant
Hmm.
in the case. So I've been appointed by the legal service authority to be the amicus curiae for respondent number 2. And as far as the delay is concerned, Lordship, I'm unable to contact the
It's okay.
As far as the state is concerned, let's take that, that's the issue.
Lordship, since there is a delay of 1,455 days, Lordship. Since there is a delay of 1,455 days, Lordship.
I have explained from para 3. Para 3 till para 7 mile.
So Lordship, I'm allowed to take a certain instruction, Lordship.
This is a matter going on for a long time for that. Why do we? It's after a civil dispute is a different aspect. It's a criminal thing, he's already there for 3 years, he has done.
Another
3 years,
10
he has
ago.
done, and I think during that period also he was there.
Yes.
How long?
Now, from the date of arrest, he is there.
Huh?
From the date of arrest, he is there.
How much?
2017.
2017, my lord, till now.
Oh, 7 years have already gone.
Yes.
I think this is the fix. Now, this is an application for condonation of delay of 1,455 days
Hearing wale kaise khatam hogi?
in filing the accompanying criminal appeal against the judgment and order dated 26/7/2018 passed by the district and session judge Zunheberto in JBTO/PS/FIR number 21/17. Pusto. It is seen that the learned court of the district and session judge Zunheberto had convicted the appellant herein. The convicted the appellant, the applicant herein. And sentence him to undergo rigorous imprisonment for 10 years and also pay a fine of rupees 10,000. And in default to pay fine accused. And in default to pay the fine, the accused shall undergo further imprisonment for a period of 3 months. It is also seen that the accused was arrested in the year 2017. And thereupon he had been he is in custody. It is further seen from the perusal of the condonation application that the Secretary High Court Legal Services Authority Kohima had appointed Mr. A. Joe, advocate as the amicus curiae, and the file was handed over to him on 16/2/2021 to
Yes.
file an appeal.
Yes, ma'am.
Thereupon, the appeal was prepared and the matter has been taken up by the legal and the Legal Services Authority. So, taking into account that the accused have been all along in custody since 2017.
My lord.
So this court is of the opinion that this is a fit case for condoning the delay of 1,445 days, 55 days
days.
in filing the accompanying appeal. Accordingly, IA stands disposed the appeal, we admit it,
My lord. Very good.
paper book not necessary,
Since also this is an affidavit, maybe
paper book will be necessary.
Will be necessary, my lord.
because they have.
But let
Paper
the
book.
first the LCR come.
Lordship. That's really.
Heard Mr. A. Joe, the learned counsel, legal aid counsel appearing on behalf of the appellant. Mr. A. V. Jimomi appearing on behalf of the state of Nagaland. And Mr. N. Mujoy, the learned amicus, so appointed on behalf by the court on behalf of the respondent number 2. First, the appeal is admitted, call for the records. First, the registry shall immediately upon receipt of the records shall prepare the paper book and thereupon list the matter
Yes,
for orders.
my lord.
For admission item number 22.
Yes.
May it please your lordship. Your lordship, I may be allowed to withdraw this petition with the liberty to fresh a file.
Why?
Your lordship, we are informed that the process for fresh election is already initiated, so we may be allowed to withdraw this petition with liberty to file a fresh.
Why? Liberty, why?
Just in case if
Huh?
her name is not, if she's
No,
not
no,
elected.
you have to ask. Answer, why? I can't give you a liberty just for the sake of it. Why? What is the case about?
Medical attendant for the post of
Then-
medical attendant, your lordship.
Then
Your lordship, the petitioner applied for the post of medical attendant.
Wasania issued a notifying the conduct interview screening of the applicants for recommendation against various posts, Geneva 2. Direct the respondent to appoint the petitioner as per the interview conducted by district. How? Why are you withdrawing it? You don't have a case.
Your lordship, because we have got we have got information from the client that the selection process is being initiated, but we are yet to receive the document.
Huh?
The selection process is being proceeded, but we didn't receive the information. We didn't receive the documents, so we want to file fresh just in case if it's needed, your lordship.
So you mean to say that there is a selection process being conducted
Yes, your lordship, ongoing, yes.
and you want to bring on record the same aspect of the matter?
Yes, your lordship.
Tell me, Darman, what do you?
Yes, if they're anticipating, I think she's anticipating some relief.
Huh?
I think anticipating relief out of the selection process, I think.
From the selection process?
Yes, so just in case she's not selected, maybe she wants to come back again. I think that.
So you have been now called for the interview?
Your lordship, we just received that she's not called, but I think
Then
selection
if you're
process is
not,
going.
how do you get the benefit? There's an interim order. Interim order for what?
For stay of the selection. Stay now.
So the interim order for appointment of AI has been stayed. Now you want to participate.
Your lordship,
At the request of the learned counsel for a petition of matter stands adjourned. Will be listed next week. Better.
For admission item number 29.
Please, Your lordship, the private respondent has not yet entered the ranks. The private respondent has not yet entered appearance with it. So we may be given the opportunity to service through justice.
The learned counsel appearing on behalf of the respondent, petitioner submits that as the service on the respondent number 5 could not be affected and there is an urgency, he would like to take steps by way of the state. So taking into account the above, list the matter again on 4th of July 2024. In the meantime, the petitioner herein would be at liberty to shall take steps by way of the state rooted through the registry of this court and file an affidavit of service by 2nd of July 2024.
Lordship, meantime, let the state respondent file their affidavit in person.
They have
Lordship, I have received my instruction. However, the documents I have received are not clear. So I've sought for more clearer documents.
in the meantime, the respondent state shall file the affidavit in opposition.
For hearing item number 32.
Yes.
Lordship, my senior is undergoing treatment out of state.
So
I do not have the instruction to argue on this matter, Lordship. I apologize. to the Lordship.
you say that you don't want to argue. I will record it. He doesn't want to argue. Madam. He expresses urgency, taking into account that a stay is operating.
Lordship, let it come up next week, Lordship.
What?
Let it come up next week, Lordship. Next week, Lordship.
Huh?
Let it come up next week, Lordship.
I'm not here. It's a part of. Where am I going? What to do with him? You don't have a case. I still remember, if the case is correct, you gave certain documents on the first day. And at the time of submission of the documents, final date, the last date, which was there, you submitted some documents. When the authorities asked you for submitting the originals, you come up with some other set of documents. So therefore, they relegated you to group 3. How many are there? Is there anybody in group 1?
Yes, 3 in group 1. Originally, there were 4 along with him. So now there are 3 in group 1 and 2 in group 3. Total 5. So if nobody comes in group 1 with suitable land, then of course he would have a chance. So he's not out of the reckoning altogether.
If anybody comes, he's finished.
This they have to be impleted.
Okay, we will extend the stay, but the loss which they will incur, you have to pay. Give an indemnity. The loss which they have incurred from 2019, the business, we have stopped. You're going to pay. What do you say?
Since I'm not the principal counsel, it's very
No,
difficult.
you are whoever it is, you are a counsel.
Lordship. Apologize, Lordship.
Hello, let me just pull it off.
Lordship, please let it come up next week.
Huh?
Please let it come up next week. Please, the principal counsel will also.
Sir, counsel, if you say 10 times, it changed my mind. It won't. It's a simple thing. I vacate the order. This can't happen. You can't get a stay. Where is the guidelines which states that these documents have to be given? Show me. You have not filed affidavit.
No, I have filed the affidavit.
Why
Filed
the
the affidavit
guidelines
is
are
that-
not going?
No, I have not
In
used-
case of any rectifiable definitely 21 days time will be given to the applicant for submitting rectified documents. The intimation for rectifiable deficiency will be sent through emails, SMS. But one thing, Mr. Bolwa, is it the same land?
That is what, my lord, that the question of evaluation of the land has not yet arisen. Because the moment he gives a different set of documents, his candidature goes. If his candidature is valid, then because all this is done on the basis of undertakings submitted by all the applicants, that whatever they have submitted is true and proper, and they are going to stand by the photocopies which are submitted with the application.
No, understood.
Yes.
But is the land the same?
We have not yet conducted any verification exercise on.
No, you have seen
on
the
the ground.
earlier document and this. document.
Yes, the land is the same. On that basis, the land is the same.
So it is only the advocate certificate which is different.
Yes, the advocate certificate and the affidavit accompanying that certificate, that is also signed by the different advocate. So it would have been easily modified by, in fact, during the proceedings, it was suggested that the advocate who had certified the earlier set of documents, they could recertify and restating that Yes, they were the persons who had
No,
submitted.
Mr. Counsel, you can't give that earlier document. You have lost it.
Yes, after getting the lottery, he was on his way to village to show his father and have a word of prayer. So while on the way by bus, he had lost the document. So he had filed an FIR in this.
Understood. Where is that advocate?
The advocate is based in Dimapur.
So can't you ask him to certify?
Yes, after it was lost, so he went back to the office. So the office told them, whatever documents is there with you, you submit that. So that's why he had submitted the other document.
Understood. But can you give a certificate by that advocate, the earlier advocate?
Yeah, by then they refused to accept.
They will you accept?
No, we asked for that only.
No, we submitted lordship. They refused to accept.
I will pass an order to that effect. Can you do that?
Lordship, we had submitted then.
Mr. Counsel,
Yes.
you want the relief or not?
Yes.
So can you submit that document or not?
Yes.
That certifying that this was the advocate, I had given this is the photocopy of this document which was there. I lost it, and as such, I am again certifying that this is my signature, or this is the photocopy is the original, and the photocopy is the document on which I have issued. I have lost the original. Can that advocate, the early advocate, give
Yes.
that certificate?
Yes. Yes, it can be done.
And if that be so, then wouldn't that suffice?
Hello, this question was posed about 1.5 years back.
Understood,
said
but
we could do it.
then we need to close it, because what
Yes.
happened, the difference is, it will be a contest now amongst, earlier it was the lottery was of 3, lottery now will be of 4. So the chance is only 1%, 25% now, earlier 33%. That is the chance. And the second is, the land is the same.
Land is the same.
So the land, I would have understood the land is different.
Yes.
It is the fault of the council which had led to this. So it may have been beyond their comparison to do so. So you file a short affidavit tomorrow, I'll take it up, that you can submit that document, which I am asking you. That the advocate, you have a hold of that affidavit, advocate. Ask him to give us affidavit that I certify this document, which document in this court. And on the basis of that, I will permit you. Your purpose is served, isn't it? Now do you need your senior? Then? So you do that. I fix it tomorrow. Can you get his affidavit to that effect? That the earlier set of documents, just for example, I'm telling you exactly what. And let's see, this is the document which you were earlier submitted. What is the advocate's name?
Kimon Thang Lotha.
Huh?
Kimon Thang Lotha.
Where is that?
Page 25.
Page
25.
25. His name is Sihaba.
Is the petitioner.
Okay. Now, this the petitioner can very well say, this affidavit. This is of 22nd of year. This affidavit of which affidavit? Where is the advocate? This one.
Kimon Thang.
It is.
And what about this document, 22nd of December 2018, Mr. Borua?
Yes, well, that is the document I'm talking about. This is clearer on page 43, 44, 45, and 46.
What?
This is the affidavit cum declaration, again 2018.
So he lost this first
Yes,
document.
yes. This is certified by Kimontum Lotha at the bottom, and page 46 also. This is the affidavit Kimontum Lotha on his letterhead. Advocate. This is the photo.
Kimontum Lotha.
Lotha.
So now who has given it?
Now has given it by one this
Sudip Narayan Datta.
Sudip Narayan,
Page 29.
20.
G1.
The annexure GS 29. The dates are also 7/2/2019,
8/2/2019.
8/2/2019.
Page 32.
Page 32.
Page 32 and dates is 7/2/2019. Earlier document which he submitted was dated
22 December 2018. Page 46.
2018. Now, what is the advocate going to say? This Kimong Thong Lutha, what is he going to certify? This document,
That, yes, this is a,
F1,
yes, sir.
that he would certify this. But
He has
what about the
certified.
other one?
And that he,
Annexer F, page 25.
page 24.
It is his document.
Yes, it is his document notarized by again the Kimontum Lotha at the bottom.
No, that is some
So
Mong Thong Lutha.
25-1 was
No, that is
lost.
also
So
Kimontum.
that's why they obtained again after this was rejected. So they made the new one, that is page 43.
Huh?
Made by the same advocate because the page 25 affidavit was lost.
No, that is why it's a separate date. No, understood. But what do you want from this document? Means he has the original of this.
He has lost it. No, no.
He that has lost the original of 2012.
2012, yes, yes.
But he has the affidavit of 7/2 original.
Yes, my lord, but that is again after a document submitted after the last date of.
Understood, but what is it? It is to be certified by him only. Who can certify that? This document, page 25.
My lord, 25 is, it has to
It
be
is his
certified.
document.
Yes, it has to be certified and attested by the notary as on being on that date. Again, signed on, thereby proving that it was submitted and notarized on 7/2/2019. Not this document, but the notary also, this is being the same person who is the advocate. He has to submit, yes, this was brought before me on 22/12/2018.
So you need a certificate by
Yes.
him
Yes,
that this affidavit
yes.
was sworn before him and he had notarized it
Yes, one.
by this notary advocate,
Yes.
Okay.
Kimontum Lotha, same. Page 20.
Kimong Singh Lotha.
Yes.
And this advocate, Kimong Thong Lotha, should also certify
Yes.
that annexure F1 was issued by him.
Yes.
That's all. We record it as your submission.
Well, that is.
Record it. The instant writ petition has been filed by the petitioner being aggrieved. We do one thing, we dispose it of. Keeping it on that,
Yes.
giving them 15 days to deposit it.
Yes.
You consider it. And if it fails, then go ahead.
Yes.
Win-win for both.
Yes.
The instant writ petition has been filed challenging the impugned communication dated 22/9/2019. Where is that? 22/2/2019. As well as the communication dated 27 2 or 3.
3. This used to be 3.
2. 27, na?
27 March.
Is it?
Yes, sir. This is there.
Page 36.
Yes, this is, they have given in the index as well. Impugned letter, 27.
What they write is different, na? As well as the communication date. No, this is his letter.
His letter.
This is what I'm saying. Where is the 27/2? 27/3. I'm saying 27/3/2019. Issued by the respondent, Indian Oil Corporation Limited. The case in brief is that pursuant to an advertisement, there was an advertisement
Yes, sir. Dated 25/11/2018.
dated 25/11/2018 for what?
For appointment of retail outlet.
For
Dealer.
appointment of for appointment or for dealership?
For dealership.
Appointment of a retail outlet dealer.
For appointment of various, na?
Ve-
Various.
One.
There's only one.
Yes.
No, normally it is many.
Normally it is many, This is the location is advertised specific one.
One. Where is that?
Page 18,
Page 18.
the application form itself specific.
No. This is different.
Yes, sir.
That it is normally given in the newspaper.
Yes, in the additional affidavit, they have given the advertisement. This is the original, yes, many outlets.
Many,
Many.
because I taking up these matters so many. Yes.
Page 5.
Had issued the Indian Oil Corporation, the respondent Indian Oil Corporation had issued an advertisement on 25/11/2018 in its official website for appointment of various retail outlet dealership in various states. Full stop.
Serial 29. Page 8.
In terms with the said advertisement, the last date of submission of the documents was on
25.
25/12/2018. Full stop. The petitioner who owns a plot of land at Indisen, INDISEN village, Dimapur, bearing village patta number 429, situated on Manjad Dimapur Road on NH 29. Submitted his application on 25/12/2018. As per the terms and conditions of the brochure, it's a brochure, no?
It's a blue.
The brochure of the Indian Oil Corporation, the manner of selection is on the basis of lottery. The applicants are divided in 3 groups: Group 1, Group 2, and Group 3. Group 1 are those applicants, the applicants who fall in Group 1 are those applicants who owns plots of land
Or has leased
or has lease of 30.
of the plot of land.
How much? There's a lease of 30 years.
Own or lease as existing. Yes,
Lease for 30 years.
yes. This
Tell
is
me,
Well, the
19
19
years.
19 years.
19 years,
19
11
years.
months.
you have that area, give it to me.
So it's in, Your Honor, it's in, the petition, page 13.
Page 13. Yes. The applicants in group 1 are those applicants who are having suitable piece of land in the advertised location oblique area, either by way of ownership oblique long-term lease for a period of minimum 19 years, 11 months, or as per the advertised in the OMC. The applicants who are in group 2 are those applicants who have a firm offer for suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months, or as per advertised in the OMC. The applicants in group C3 are those applicants who have not offered land in the application. The petitioner, it is also one of the stipulations in the said application, in the said brochure, that there has to be an affidavit filed in support of the land to be offered, along with a certificate to be given by an advocate. The petitioner, who claims to be the owner of a plot of land, submitted his application on 25/12/2018, along with the advertisement, along with an affidavit dated 22/12/2018 in the proper format. In addition to that, the petitioner had also submitted a certificate issued by a counsel, by an advocate, namely Sri Kimong Thung Lotha, dated 22/12/2018. Whereby he had duly certified that, in his opinion, that the plot of land offered by the petitioner falls in group 1. Subsequent thereto, on 22/2/2019, subsequent thereto, at the time of verification, the respondent corporation sought for the original of the affidavit dated 22/12/2018, as well as the certificate issued by Sri Kimong Thung Lutha, advocate. However, the petitioner submitted an affidavit containing the same contents dated 7/2/19, as well as a certificate by another lawyer dated 18/2/2019. Under such circumstances, a communication was issued via email dated 22/2/2019 that the land documents submitted by the petitioner are not valid for considering the offered land under group 1. And as such, the petitioner herein was relegated to group 3. The petitioner, on coming to learn about the said email, submitted a communication on 25/2/2019 stating inter alia that the earlier certificate, original certificate dated 22/12/2018, as well as the affidavit come undertaking also, na?
Undertaking.
Dated 22/12/2019 was lost for which an FIR have been duly filed. And as such, the petitioner therefore requested the head of the division, Tinsukia Divisional Office, to consider the affidavit come undertaking dated 7/2/2019, as well as the certificate dated 7/2/2019 issued by the advocate. 7/2, na?
7/2. 8/2.
8/2.
8/2. 8/2.
The respondent authorities by the communication dated 27/3/2019 observe, inform the petitioner that Appendix Roman 3B, which is the advocate's letter, is of the date later than the date of the application, which is treated as not non-rectifiable. It is under such circumstances the instant writ petition was filed. No, full stop. Subsequent thereto, the petitioner again submitted on 10/4/2019 a fresh affidavit cum declaration dated 8/4/2019, which was notarized before. The advocate and notary public Sri Kimong Thung Lotha. In addition to that, a certificate, in addition to that, the certificate which was submitted by Sri Kimong Thung Lotha on 22/12/2018 was again certified by Sri Kimong Thung Lotha on 8/4/2019. However, the same have not been considered, and the respondents fixed a date for draw of lots on 18th of July 2019. And as such, the petitioner approached this court by filing the instant writ petition. This court, by an order dated 16/7/2019, issued notice, and in the meanwhile directed the respondents, restrained the respondents from drawing fresh lots on 18/7/2019 at 12:15 PM until further orders. There was no modification of this order?
My lord, I entered the scene, the earlier council holding the brief, he expired, so I came only on scene in 2022. Till then, there was no modification of the said order.
No, that means it state everything.
No, my lord, it said only that.
No, the order says only this.
Yes, my lord, but the others proceeded and they never objected because their objective was met.
Thereupon, the said stay order continued. Various pleadings have been filed in the meantime, which this court have duly considered. I've heard the learned counsel appearing on behalf of the Mr. So-and-so. What's your name? So-and-so. Give your name. The learned counsel appearing on behalf of the petitioner submitted that it was on account of the fault of the counsel who lost the original affidavit come undertaking. Who lost? Council lost or you? You lost.
Yes, the clients lost.
The council, the learned council.
It was lost.
It was
Stolen from the bus.
submitted that the petitioner, due to reasons beyond his control, have lost the original of the affidavit come undertaking dated 22/12/2019, as well as the certificate issued by Sri Kimong Thung Lotha on 22/12/19. Under such circumstances, when the originals were sought for, the petitioner, in order to furnish a fresh copy of the a fresh affidavit come undertaking dated 7/2/2008 to 7/2/2019, and another certificate of another advocate dated 8/2/2019. He submits that the certificate as well as the affidavit are only to the effect that the petitioner falls in group 1 footstep. Inasmuch as the petitioner duly has the original documents, land documents. Footstep. He further submitted that when this aspect of the matter was brought to the notice of the authorities had relegated the petitioner to group 3 as if the petitioners did not offer any land. Be that as it may, the petitioner even tried to submit an authenticated copy, submit another copy of the affidavit come undertaking before the same notary dated 8/4/2019, as well as a attested copy of the original photocopy of the advocate's opinion dated 22/12/2019, 18, which was attested on 8/4/2019. However, the respondent authorities have not taken into consideration the said aspect of the matter. He therefore submits that the actions on the part of the respondent authorities are arbitrary and also discriminatory, for which the instant proceedings, the respondent authority, the relief which have been sought for by the petitioner ought to be granted. On the other hand, Mr. N. Bulwa, appearing on behalf of the respondent corporation, submitted that the certificate which was submitted earlier at the time of filing of the application, along with the affidavit, was a different certificate from that of the certificate which was submitted, original of the certificate which was submitted subsequently. And as such, the originals of the original certificate having not been placed before the court, before the respondent authorities, on the basis of the photocopy of the original certificate dated 22 of the certificate dated 22/12/2019 and the 18 and the affidavit in come undertaking dated 22/12/2018, the respondent authorities were justified in relegating the petitioner to Group 3. He, however, submitted that the respondent authorities are not adverse to accepting a certificate issued accept the photocopy of the
not the photocopy, not averse to accepting the documents, provided they be recertified by.
No.
Yes.
I put it in a better way.
Yes.
I'm not adverse to it, accepting the photocopy of the affidavit come undertaking dated 22/12/2018, as well as the certificate of issued by Sri Kimong Singh Lotha dated 22/12/2018, provided Sri Kimong Singh Lotha duly swears an affidavit and submits before the respondent or corporation that he had duly certified. I think this will be better, nah? That he had duly issued the communication dated issued the opinion dated 22/2018. And the contents of the opinion, the contents of the photocopy of the opinion dated 22/12/2018 of his opinion dated here are correct. In addition to that, the said Sri Kimong Singh Lotha should also submit an affidavit, submit in the same affidavit that the affidavit undertaking was executed in his present before him, the dated 22/12/2018 was executed before him by the applicant, and the contents the notary cannot say anything about it. And yeah, full stop. Does the affidavit says that he has prepared it?
No.
It doesn't say, no?
It doesn't say, It
Okay.
has been only affirmed and declared before him. Only affirmed and declared before him.
That it was yeah. Full stop. Mr. Kuswencho, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be in a position to produce the said affidavit as have been sought for by the respondent corporation. However, he submits that some time may be granted for that. Taking into account the above, this court is of the opinion that this court, having perused the affidavit come undertaking dated 22/12/2018, the opinion dated 22/12/2018 of Sri Kimong Singh Lotha, as well as the affidavit which was submitted on affidavit come undertaking dated which was submitted on 7/2/2019, is of the opinion that the land which have been offered by the petitioner appears to be the same land. It is on account of the original certificate opinion dated 22/12/2018 of Sri Kimong Singh Lotha, as well as the original affidavit come undertaking dated 22/12/2018 having been lost the petitioner had submitted originals of a freshly made affidavit come undertaking dated 7/2/19 and opinion dated 7/2/19. Full stop. Taking into account that the respondents are not adverse to accepting an affidavit in the form and manner already stated herein above, and the petitioners are willing to submit, the petitioner had expressed their willingness to submit an affidavit into that extent. This court is of the opinion that the petitioner herein be granted 15 days from today for submitting an affidavit. And in the circumstance such affidavit is filed within 15 days from today, the respondent authority shall consider the opinion dated 22/12/2018, as well as the affidavit come undertaking dated 22/12/2018, as if the originals have been submitted. Thereupon, the respondent authority shall duly take up consider the case of the petitioner within the purview of the above as per its established norms.
As per the brochure.
As per the brochure. Dated, what is the name of the brochure? Every year there's a different
Well,
brochure.
in this case, it is only the name is given brochure for selection of dealers.
Dated year.
Well,
There's a year
2009.
2018.
2018. Brochure dated, you just give the name, just show it to me. Full stop. The interim order passed earlier stands no longer survives in view of the above adjudication, and the respondent authority shall proceed with the selection of the dealership on the basis after duly considered the case of the petitioner subject to the petitioner submitting the affidavit as directed above. Okay, you are asking for your senior.
For hearing item number 57.
This thing would have been done long time back, no?
Because a proposal twice the time was given to
No,
different.
now they have no option. If they don't submit that, there is no option. Yes, what is this matter? Criminal petition? Who is appearing? Takat issue. Taking a petitioner is not doing that, this is the matter again on it. Oh, this matter. Where is he? That person from Manipur. Isn't that the case?
Yes, okay.
It's shown as Pathad.
Yes.
Okay. Oh, yes. Madam, you are there in the car.
Yes, Your Honor. Yes, Your Lordship.
Yeah, tell me. I asked you to find out something.
Yes.
Oh, the records are here.
Yes.
Lordship, and intimation for re-investigation was done as per the CD. After the charge was submitted, intimation was given to the court for investigation, and a warrant a warrant for arrest was sought for, and which was granted. And investigation is still going on. Now the attempt was made to arrest him, but
he's absconding.
Yes.
There's no stay.
No, there's a stay of the warrant arrest. That's it.
Here?
Yes. On the first day was
when
non-billable warrant of arrest was suspended till the next one that was issued on 26/5/2022 of it.
Warrant of issue.
Yes.
Okay. So this order is very clear.
Yes.
Submitted the Learned Council for Witness in pursuant to an FIR registered and so in one after the learned year to cognizance of the offence and issued a non-bailable warrant against the petitioner. Being aggrieved by the registration of the case so and issuance of a non-bailable warrant, the applicant hearing before the court challenges the proceedings of CR and issuance of warrant of arrest. Also submitted the charges are clearly and that there is no prima facie case has been here. Now, subsequently, there is a fresh supplementary charge sheet submitted.
Not yet, Lordship. Now, now in the process, even the LCO was called for. I think that is one of the things that could not be possible below before the trial court. I think that one expect. Then the situation, unpleasant situation happened last year. So now the IO could not even proceed to
We return to file. Yes, Mr. Counsel. There is a reinvestigation order.
Milord,
There is a reinvestigation order.
passed by whom, Milord?
Yes, that the order has been done under 173(8). Then
That is passed by the Chief Judicial Magistrate, Milord.
oh, obviously the Chief Judicial Magistrate has the power to do that.
When the cases like stay, all the proceedings are stayed by this honorable court. So under what circumstances that can be invoked into?
Where there is a stay?
Stay orders like as and when I got the interim order.
You got the stay order on 26/5/2022.
Yes, Milord. 26/5/2022.
Prior to that, there is an order of
yes,
reinvestigation.
yes.
Then
Or that
the entire case is on the basis of a charge sheet. The court has gone for a further investigation. Then this is not a fit case.
yeah, in that case, it may be in practice, to my best of knowledge, like that this should have been just informed to the court. In fact, that should have been informed to the court by the councils, respective councils of the who present.
Against you, there is a search warrant.
Yes.
There is a warrant of arrest.
Yes, yes.
That is why you do want.
Milord.
Investigation is not complete.
No, not yet.
So now he is not yet been arraigned as an accused in that criminal case. Has he been arraigned as an accused? He can't be arraigned as an accused unless there is a fresh charge sheet or has the court exercised that power.
Yes, Milord.
It is here said that the suspected accused person, namely Mr. N.T. Luang, it's clearly said like
what
in the charge in the city he's arraigned as accused. Lordship.
We do one thing. Let's see. Where is that order? Last order. What is happening? Let's see. 21. Received subsequent bail application praying for release of Abhishek Iman, so and so Iman. Yeah, we should summons to PW4. Yes, how is the court proceeding? Oh, wait. There's a long order. Civil Judicial Magistrate 1610, so and so Defense Counsel submits. Present for the accused Abhishek Bora. This is going on. Law, so and so. Entry, so and so objects a bail. Hence, I have heard so and so more than 3 years a month, trial was 3 years a month. The accused person can make it secure his presence before the Now, you see, on one hand, the investigation is going on. And one hand, the court is going into PWs. What is this?
I think that is must be in respect of the one of the
As of now, what will happen later on? They propose to make him under that provision later on. Bring somebody. PW4 it is going on, government council, yeah, it's an application of 236A. Abhishek Bora, he has been granted bail. Government council, district jail, Kohima, is the order, district jail. Yeah. Got something. Record for prayer, yeah, the case praying to the court to issue warrant of arrest, production warrant of transit against the accused N.T. Luang, so and so to corporation officer Imphal, who wanted Sri Kohima in collection with so and so. Peruse the prayer, satisfied, prayer is allowed. Production will be issued against the above named persons. The order be treated as a transit order, and this order has been stayed.
Yes.
Okay, now, is there any application, must be application signed?
And on the day it was stated, the record was called for. The record, CR was called for.
This is the record.
Yes. So I think no further proceeding thereafter, I think.
We don't require the record.
Yes.
We return the records. And what is your case? The investigation is going on. Why should we stop it?
Lordship.
You do one thing. You appear before that court and seek bail, regular bail.
My humble request before this honorable court is like, in as much as this case is concerned, the maximum punishment which can be awarded to my client, assuming that he has committed the crime of cheating, that is up to 7 years, my lord. So in view of that, so Anis Kumar guidelines has to be at least complied by the investigating authority.
Mr. Counsel, why don't you do one thing? Why don't you file a bail application also?
My lord, I may resort to that provisions of law. It's quite obvious from my side. I can initiate. In the meantime,
This case
how
would
the
not file an anticipatory bail application. You can very well file an anticipatory bail application. So why you are not doing it? This is not a case for staying the warrant of arrest and all, because you are not participating in the earlier CD also, the case diary also doesn't seem that it has been done in that manner.
My lord, to my best of knowledge, no summons have been served, accepting that non-relevant warrant of arrest for the issuance of other than those things. I didn't have any summons being served.
Counsel, I understand everything. I understand everything, but why you are not applying for a regular the anticipatory bail here?
Not to that extent.
I do one thing. I'll send back the records. I keep the matter pending. There is a stay now. You apply the anticipatory bail, and thereupon let the for that time being. I think that is a better option. You are safe for the time being, but you have to apply for it. But this cannot go on. We cannot stay this. When there is an investigation still going on.
Yes, not right.
Investigation is going on. You are shown as an absconder.
Yes, I'll suggest to my clients, my lord. In the meantime, my lord, would it be valuable to cite one of the very recent judgment passed by the Supreme Court, my lord, in this regard? This says how a charge sheet has to be furnished to the court. So in view of that section 173, so all those things are not complied with, my lord. By not entering to the merit of the case,
have granted the permission for further investigation. How do you take care of that?
Oh, I didn't have that knowledge, my lord.
You don't have
that is so.
You are there in Imphal.
That was not so far as my knowledge is concerned. I'm in receipt of that information. So what non-relevant warrant. Other than those things, I didn't have, my lord. And it is clearly stated that even in the charge sheet, it is clearly, if I happen, I'm just alleged to be an absconder. or
So
it should have been just.
thereupon the court had directed further investigation. And as such, they have they are going ahead with the further investigation, and thereupon this there is a warrant of arrest has been issued to you. It is in connection with that.
In that case, I may.
Case which happened out here earlier was this.
Yeah. In that case, Milord, I may comply the direction given by this honorable court. I wouldn't have any issue, Milord.
Huh? The hook. This is an applicant, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. V. Angami, the learned counsel appearing on behalf of the respondent state. And where is that lady? Yes, in the car.
Yes, Your Lordship.
Yes. Your name?
Nancy Lota, Your Lordship.
And so appearing on behalf of the respondent number 2.
Yes, Your Lordship.
Okay. Okay. This is an application filed for washing of the FIR number 13/2017 in connection with GR case number and for washing of the FIR in connection with charge sheet in connection with GR number CS Kohima (N) Police Station FIR number 13/2017 registered under section reference GR number 53/2017 under section 406, 419, 420, 468 of the Indian Penal Code. It appears that an FIR was filed by the respondent number 2 alleging we'll do one thing. I have to write now. Take up tomorrow. I'll pass the order tomorrow.
Oblige,
Oblige, Your Lordship.
Courtmaster, sir. Courtmaster, sir, can you hear me?
Yes.
Sir, item number 51 has been adjourned.